Hi, my name is Gary Williams, and I'm here to give you some important information about what happens in child support hearings, and then later on, explain a little about the Child Support Agency and its role. After you arrive at family court, you will need to go to the waiting room near where your case will be heard. When you arrive at the waiting room, look for the list of cases on the wall outside the hearing room and make sure that your name is on the list. Your case may not be called in the order listed, so please be patient. Each waiting room has uniformed court officers who are responsible for security during the hearings and the safety of everyone in the building. Court officers also announce to people in the waiting room when it is time to check in. After the court officer makes the announcement, you should check in. And when you check in, tell the court officer if you need an interpreter or if you have an order of protection against the other person. We do not recommend that you bring your child into the hearing room, but if you do have your child with you, you may want to consider taking them to the Children's Center located in this building. If you don't know where the Children's Center is located, ask the court officer for directions, but make sure that you have checked in first before you leave. The Children's Center is free of charge and provides a safe and fun environment. When it is time for your case to be heard, the court officer will call your name. If your name is called and you are not in the waiting room, you may have to wait longer, or your case may be decided without you or even dismissed. If you have to leave the waiting area, tell the court officer and make sure you return as quickly as possible. Do not leave for more than a few minutes. Also, please be considerate of others who are waiting. If you need to make a cell phone call or talk with others, please talk quietly so that you do not disturb those around you. Be patient and stay in the waiting area until your name is called. While you're waiting, check to make sure that you have the documents you need, including copies of most recent pay stubs, most recently filed tax return, a notarized financial disclosure affidavit, and orders of support for other children, plus receipts for any child support already paid. If the child lives with you, you will also need copies of the child's birth certificate, voluntary acknowledgement of paternity form, if completed, marriage license or divorce decree, and proof of what you paid for medical insurance, rent, food, clothing, child care, education for the child. If you filed the petition, you should also have your completed affidavit of service form with you to show the support magistrate. If you don't have some of these documents, you should tell the support magistrate which documents you don't have when you get into your hearing. So let's review the other people who will be at your hearing. A support magistrate is the person in charge of the hearing and is responsible for listening to both sides, looking at all of the information provided, and following the law to make a decision about the case. You've already been introduced to the court officers. A clerk sits near the support magistrate to prepare the paperwork for the court order and also to tape record the hearing. The petitioner is the person who filed the petition. The respondent is the person against whom the case was filed. Both parties may hire an attorney if they wish. The attorneys would sit next to their client. If the child in the case is receiving public assistance, the petition is filed by the Department of Social Services, also referred to as DSS. In public assistance cases, DSS always has an attorney present. This attorney represents DSS, not the custodial parent. DSS files the petition so they can get the non-custodial parent to repay the government for the assistance the child is receiving. In public assistance cases, a petition for paternity and/or child support must be filed, but the custodial parent is not responsible for filing the petition. DSS files the petition. The custodial parent appears only as a witness for DSS. Finally, you should be aware of some rules you will need to follow when you are in the hearing room. You cannot chew gum or wear a hat. You need to speak clearly and loudly so that everyone in the room can hear you. You should not interrupt when other people are talking. You should not swear or curse. You should direct all comments and questions to the support magistrate, not to anyone else. And if you have any questions, you should wait to ask them until the support magistrate indicates it is your turn to speak. Now that you know the people involved in a hearing and the rules, let's see how a hearing works. We will begin after the court officer has walked the parties to the hearing room and directed them to their places.
Thank you.
This is number 7 on the calendar, F51827-46 in the matter of Johnson versus Jones. Please raise your right hand. Ms. Johnson, do you swear or affirm to tell the truth during this proceeding?
I do.
Would you please state your full name, complete address, and your Social Security number?
Monique Johnson, 70 Placid Avenue, apartment 3C, New York, New York, 10001. 123456789.
Please raise your right hand. Mr. Jones, do you swear or affirm to tell the truth during this proceeding?
Yes, I do.
Please state your full name, complete address, and Social Security number.
My name is Marcus Jones, 923 Pearl Street, apartment 13H, New York, New York, 10003. 987-987-654321.
Both parties have the right to request an adjournment in order to hire an attorney, or you may waive the right to counsel and speak for yourselves.
Let me explain what the court officer is saying. Both sides have the right to hire an attorney, but you don't need an attorney to proceed with your case. You can waive your right to an attorney and speak for yourself. If either party wants to hire an attorney, the support magistrate may adjourn the hearing to a later date. Depending on the type of case, when a hearing is adjourned to hire an attorney, the court may issue a temporary order of support until the date of the next hearing. A temporary order means that the respondent must pay the amount stated in the temporary order until the next hearing. Now, let's get back to the hearing.
Ms. Johnson, do you wish to request an adjournment so that you can hire an attorney, or would you like to speak for yourself?
I'll speak for myself.
Mr. Jones, would you like to request an adjournment so that you can hire an attorney, or would you like to speak for yourself?
Speak by myself.
Thank you. You may both be seated.
A support magistrate can hear 4 types of petitions. The first type, a paternity petition, seeks to establish the legal father of the child when a child was born to parents who were not married to each other. It is very important to tell the support magistrate if the mother was married to anyone at the time the child was born. Either party may request DNA testing at the paternity hearing, or the man may choose to admit that he is the father. Depending on a variety of factors, the court may issue an order for the parties to appear at an approved lab and submit a DNA sample. If the request for DNA testing is granted, the case will be adjourned. After the DNA test is complete, the parties return to court, where the support magistrate reviews the findings of the DNA test. If the court finds that the DNA test indicates that the man is not the father, then the paternity petition is dismissed. If the DNA test indicates that the man is the biological father, and the man still denies that he is the father, the court will hold a hearing. If the court determines that the man is the father, it will issue an order of filiation, which declares that the man is the legal father of the child. After an order of filiation is issued, the father has the right to pursue custody or visitation with the child. However, custody and visitation are different from child support and require a separate petition. The support magistrate cannot determine issues of custody or visitation. After an order of filiation is issued, the court may determine child support. The second type of petition is a support petition, which seeks to establish an amount of money that the non-custodial parent will need to pay until the child turns 21 or becomes emancipated. That amount will include money for basic support, plus a share of medical and child care expenses. The court may also order the non-custodial parent to pay other expenses, such as private or college education costs. In addition, the support magistrate may order that the child be enrolled in one of the parent's health insurance plans or make other arrangements for health insurance coverage. The third type of petition is a modification petition, which can be filed by either party when there has been a legally significant change in their circumstances since the last order was issued, or when the basic needs of the child are not being met by the support order. It is important to know that when either parent voluntarily decreases their income, for example, quits their job or becomes incarcerated, the court may find that this parent is not entitled to a modification of the support order. A parent who does lose their job must demonstrate to the court that they have looked for a new job. However, if non-custodial parents do experience a significant change in their circumstances, or if there has been a change in the custody of the child, they should file a modification petition as soon as possible so that they do not get behind in their payments. The fourth type of petition is a violation petition. This petition is filed either by the custodial parent or DSS when the non-custodial parent does not pay child support. If the non-custodial parent has not paid child support, the support magistrate may enforce the order in a number of ways, including suspending professional or driver's license, issuing a money judgment, or even jailing the non-custodial parent for up to 6 months. Now that we've reviewed the different types of petitions that lead to child support hearings, let's look at how child support payments are actually calculated. We've asked our child support reporter, Liz, to look at how the support magistrate calculates the amount the respondent will be ordered to pay.
Thanks, Gary. I've talked to a number of support magistrates, and they tell me there are specific support guidelines that they are required to consider. To calculate the amount of money the non-custodial parent will be ordered to pay, the support magistrate would look at a number of things, including the number of children involved in the case, both parents' incomes, whether the child is covered under one of the parents' medical insurance plans, and whether there are other costs for the child, such as child care, education, and medical costs not covered by health insurance. The support magistrate uses the support guidelines to determine the amount the non-custodial parent will pay for basic support. The support guidelines set a percentage of the non-custodial parent's income to be paid for basic support. The percentages vary depending on the number of children for which support is being requested. The percentages are 17% for one child, 25% for 2 children, 29% for 3 children, 31% for 4 children, and at least 35% for 5 or more children. In addition to the amount based on the guidelines, both parents may be ordered, based on their incomes, to share the cost of expenses related to child care, educational, and unreimbursed medical expenses. After the support magistrate determines the amount to be paid for support, he or she calculates the amount of retroactive support. This is the amount that would be owed if the payments had started on the date the petition was filed, or for public assistance cases, the date the child began to receive public assistance. To repeat, the total amount that should have been paid starting on the previous date is called retroactive support. That's how child support is calculated. Gary, back to you.
Thanks, Liz. The support magistrate will also credit the non-custodial parent with any money paid under a temporary support order or a previous order. So the non-custodial parent should bring receipts for any support already paid. Copies of the Child Support Standards booklets are available in the hearing room, and the booklets show how much support is due for each level of income. If you are still confused about how the amount will be calculated, please pick up a copy and review it. Before you leave your hearing, you will be handed paperwork that will tell you your account number, how much you will have to pay, the date that your first payment is due, where to send your payments, and other useful information. If the order is a temporary order, you will also be given a slip of paper with the date of your next hearing. Be sure to return to court on that date, or the case can be decided without you. Keep all the information you receive at your hearing. Read your court order carefully to make sure that you do not violate the order. If you are employed, the Child Support Agency will send a notice to your employer, telling them how much you owe and when it is due. This is called an income execution. It is your responsibility to make sure that your employer sends the payments in full and on time. Remember, it may be a few weeks before your employer receives the income execution notice. In the meantime, you must send a money order or certified check made payable to the Support Collection Unit to the address on the screen. Payments may also be made through participating Western Union outlets throughout New York State. Please note that there is a minimum $3 fee for using Western Union. To make sure that you get credit for each payment, all payments should include your complete name, your child support account number, and your address. That's what you need to know about the court hearing and payment process. So now, let's go back to Liz for a look at the Child Support Agency and what it does. Liz?
Thanks, Gary. The main thing to know is that the Child Support Agency is not part of family court and is a separate agency that works to ensure that the children get the money that the court ordered in full and on time. The Child Support Agency has the authority to enforce the court order through a variety of ways, including issuing an income execution to your employer. The income execution tells your employer to deduct child support from your paycheck and to send in the payment on your behalf. You should also know that if you stop paying your child support, the Child Support Agency can take various actions to collect the arrears, the amount that's past due. Some of these actions include suspending your driver's license and passport, intercepting state and federal tax refunds and lottery winnings, taking money directly from your bank account, and taking property such as cars and other physical assets. Before any of these actions are taken, non-custodial parents will be sent a notice describing when the action will be taken and what can be done to avoid the action. Gary, to be sure non-custodial parents receive these important notices, they must tell the Child Support Agency if either their address or employer changes. Back to you, Gary.
Thanks, Liz, for that important advice. I hope you have a better understanding of what will happen at your hearing